Very good evening, everyone. We apologize for a small delay. And we start today our class number 4 from our Business English series. And sorry for some technical issues. We're today from a new place, and that's why you can see there are some technicalities. So we're very glad to welcome you tonight, and I'm extremely happy to present you our virtual English specialist, Alexandra Dolce, an attorney from New York who's going to speak about very, very complicated and specific issues, but extremely interesting and important. We will try today, for the first time, to try voting through our online system. If it fails, that's okay. We will be then asking you questions, and you will be able to comment and to answer on YouTube comments. You are very welcome. And once again, please, if you have any questions, please do ask, and I will be directing your questions to our Alexandra, our specialist. So Alexandra, the floor is yours.
Slides next to me, so if something goes wrong on the screen and there's a lag time, it's probably because I'm looking to catch up to be able to see what's on the hard copy. That's one. You may hear Sophia say, Alexandra, hands. I'm a New Yorker. I talk with my hands a lot. So if she says that, it usually means that I have to put my hand down. But besides that, that's basically it. So what we're going to do today, we're going to start with Reg D, agency, corporate government. And Reg D and corporate governance has to deal with corporations specifically, and agency has to deal with almost everything. So we're going to start with Reg D, and then we're going to end with corporate governance. I hope you enjoy the presentation, and I'm going to be starting. All right, so Reg D, this is the site 17 CFR section 230.50 rule 504. So the Securities Act of 1933 states that every offer to sell securities needs to be registered with the Securities and Exchange Commission. However, there are certain exceptions. If an offer meets specific criteria, it's eligible for an exemption from such registration. The SEC's Reg D is one of such exemption to registration. So basically, if you're selling securities, if a corporation is selling securities and basically sell securities, why? To raise money, then they can be exempt under Reg D. Okay, the term security means a lot of things. It means any note, stock, treasury stock, security future, security-based swap, bond, evidence of indebtedness, certificate of interest, participation in any profit-sharing agreement, et cetera, et cetera, et cetera. So security is basically anything that the corporation is selling in order to make money, in order to raise cash. Okay, that's a security. Very, very general term. So for Reg D contains a set of rules set by the SEC that allows an entrepreneur or a company to sell securities without registering with the SEC. That's very important because the SEC has a lot of forms that you have to register. In order, every action that you take, you have to register. So, or most of the actions that you when you're running a corporation, you have to register, or you have to run by the SEC. That's called disclosure. But this is basically with Reg D, there's an exception. It's intended to help small companies and startups that otherwise couldn't bear the cost of a standard SEC registration gain access to the capital market. So it's for smaller companies. Thanks to this regulation introduced in 1982, companies can raise capital selling equities and debt securities. Debt securities are negotiable or tradable liabilities or loans. Examples are bonds, notes, and commercial paper. Okay, so everyone knows what bonds are, notes, and commercial paper.
Well, if you don't know, can you please ask us? And yeah, we will just explain in more details. Yes, and can I ask a question? So, if we speak about the topic of our classes, why it is important for us to be aware of this Reg D, because I bet a lot of our viewers are not absolutely familiar with this, and it's like a new territory for us. Like in general, why it is important for us to study it and to look at it. So
okay, so Reg D is important because if you're dealing with a startup or a small corporation that's trying to sell securities or trying to raise money, then this is maybe an easier way for them to do it. And you could advise them that this is an easier way to do it. You don't have to go, the regular route. You're a smaller company. You don't have that much money. So you go this route. It's easier for you. It's easier for you to raise money. And basically, it's also easier for you to save money because you don't have to go through the SEC to register to gain access to the capital market. Because in order to gain access to the market, you have to register with the SEC. There's a lot of thick forms that you have to do, and you have to pay some money.
Okay.
A significant amount of money. So if you're a smaller company, you may not have that money.
Yes.
So that's the advantage.
And there is one question from Daria. So the question is about the last line on the slide is about a commercial paper, because we're kind of understand, bonds, obligации, notes, sort of vexilla. And what is a commercial paper? Commercial paper is what? It's an unsecured promissory note. So remember we talked about secured transactions before? It's secured by something. This is unsecured. So I'm just giving you a commercial paper saying, okay, if you invest $1,000 in 7 months, I'll give you $1,050. But it's unsecured. That's just basically what commercial paper is. It's just a transaction. It's a negotiable instrument. It's a promissory note. I promise to give you this amount of money if you give me this amount of money. That's basically it. Okay. Okay. Thank you very much. Okay. The company or entrepreneur must file a Form D disclosure document with the SEC after the first securities are sold. Form D is very, very important. Once you get some money and you raise some equity, Form D has to be filed with the SEC. Again, there are penalties if you don't do this. Trust me, and the SEC is on it. Okay. Corporations that use Reg D, the Reg D option should understand, first and foremost, what they should understand, what makes their company eligible to use Reg D. So not every company can use Reg D, okay? How to disclose required information to investors with a private placement memorandum. So a private placement memorandum, PPM, serves as a single comprehensive document outlining the material details about the offering, okay? So basically, this is what we're offering. We're offering promissory notes. The promissory note, the date will begin, the date will end. We promise to give you, let's say, 25% interest for every $1,000, et cetera. That would be the private placement memorandum. So it basically delineates what the offering, what the company is offering, specifically delineates it. Okay. Reg D continued, how often forms must be filed? Because like I said, everything that you do, the SEC regulates it. There's a form for it. Potential consequences of using Reg D. Again, you know what I mean? You're a smaller company. You're using Reg D right now, but as you grow, you may not be able to use Reg D. Or, you know what I mean? You may be able to use Reg D now for 12 months, and maybe 12 months later, you may have to halt it and wait for another cycle before you can use it. So there are consequences of using Reg D. So it does have its advantages, but also has some consequences. So yeah, of course. Need to be aware. Okay. So under the SEC Regulation D, there are two major rules that create exemptions for companies to make private offerings. Rule 504 is SEC regulation that allows companies to sell up to $10 million in securities in a 12-month period without registration. So remember, I tell you, 10 million within a 12-month period. Okay, so that's basically it. If you don't know that, based on what I said, if you don't know that and you sell 12 million, there could be an issue. Okay, the company must file Form D within 15 days of the first sale. It must also comply with all regulations and laws in the states where the securities are being sold and offered. Okay, so again, SEC regulates the transaction, but there are a lot of other laws, state laws and federal laws that apply when you're dealing with transactions like that. That's very important to know. Very, very, very important. Some companies are not eligible for 504 exemptions. These include investment companies, Exchange Act reporting companies, companies with no specific business plan, companies that plan to engage in a merger or acquisition with an unidentified company or companies that are liable for bad actor disqualification.
Okay, so some companies, not everybody, although you're small, not everybody can do this. Okay, exemptions established by Reg D, Rule 506. A company that qualifies under Rule 506 can raise an unlimited amount of capital in offerings, as opposed to 10 million. The seller must be available to answer questions from buyers, and buyers receive restricted securities. Okay. As with previous Rule 505, a company operating under Rule 506B may sell to an unlimited number of accredited investors and up to 35 non-accredited investors. Unlike under Rule 505, however, all non-accredited investors must be considered sophisticated. That means they must have enough of a financial or business background to evaluate the potential risks and rewards of the investment. Okay. So non-accredited investors are any investor who does not meet the SEC's income or net worth requirement. So there's a requirement. And if you have a certain net worth or income, then you're accredited. If you fall below that, then you're non-accredited. Okay. So if you're non-accredited, that means you must be considered sophisticated, which means you have enough financial or business background to evaluate the potential risks and rewards of investment. So which means if I'm trying to raise capital and I'm trying to get a Reg 506 or 505 or 504 exemption, and hold on, I want to go back because
and I have a question about going back, so there will be also a question.
I did 504. I did not mention 505. Okay, because 505 has merged into 504, so they're basically the same thing. So, but before it was 504, 505, and 506. So 505 is basically now the same as, very close to 504. Okay, very important. Okay. Anyway, you were going to ask me something?
Yes. Can we return to a previous slide? We have a question about the as we are going to speak about mergers and acquisitions next time. The next one where it was, yes, this one. There was a question about one term over here about companies that plan to engage in a merger or acquisition with an unidentified company. So what does it mean, unidentified company? Why I'm asking, because, through our Telegram channel, we have a question about this, because a person doesn't understand that a merger or acquisition usually happens with someone you know. So there is a identified company. So this caused the confusion.
Just because you know them, that doesn't mean you identify them. Identify means disclosing who the company is. You see what I'm saying?
So it's unidentified in the eyes of like any authorities.
Yeah, basically, it's not even unidentified. I'm not telling you, okay, I'm merging. Okay, I know who this company is, but I don't want to tell you. I'm not ready to tell you if we're merging yet or where I'm acquiring it yet. So it's unidentified.
I understand.
Okay.
Yes, understandable.
Limitations of SEC Regulation D. The benefits of Reg D are only available to the issuer of securities, not to affiliates of the issuer or to any other individual who might later resell them. Okay, so it's only to the person who's issuing the securities, the notes, whatever, the promissory notes, etc. What more, the regulatory exemptions offered under Reg D only apply to the transactions, not to the securities themselves. You have to understand, this is a transactional thing. The securities are governed by how you trade the securities, what type of securities, and how the securities are sold are also governed by federal and state law, the state that you're in. So you have to basically go and make sure that you're following all the laws in terms of how you're selling this, what constitutes commercial paper, what constitutes a note, whatever. Those have to be satisfied. That those issues have to be dealt with and researched, in addition to the transaction of, filing an exemption under Reg D. Very, very important. So it's not, okay, I have Reg D and I could sell this and I could sell it whenever. No, you have to follow the other. That's why it's so complicated.
Yes, it is very complicated.
Okay, so the poll is open.
All right, so everyone, let's give it a try. So what you can see up on the screen, you can see the the numbers. So what you need to do, you need to go to VBox app. So just type in VBox app. So, and I'm trying to do it with you. And over there, as you go, so you literally type in VBox. So you need to join a session. So you need to type in on the main screen the number of the session 197 that you can see up on the screen. So 941 and 796. And after you have joined the session, you can see that there are 2 questions. Yeah, it works, Alexandra. Magic. So, and there you can answer the question. So we understand that it takes some time for you because we have a slight delay, like in 20 seconds when we are having a class via YouTube. So you need to try to answer this question. And then Alexandra will stop the poll and we will see who answered what. So it will be like an anonymous poll and we will see the numbers. And it works, so we'll see. Yeah. So, and okay, so so the question is, are companies with no specific business plan exempt under Rule 504? Okay, so, and as you can see, we have got, and we can see the numbers. We can see that 13 people have managed to join, 8 already voted. We'll wait for just a little bit. So, and while we are waiting, let's explain a very easy word, but maybe it might not be clear to someone, and we're asking this question. So, Alexandra, what does it mean exempt? How else we can say this word? So,
when you're exempt from something, you don't have to do it. There are certain things that you don't have to follow. Certain rules or certain procedures you don't have to follow. Okay, for instance, I'm licensed in New York as an attorney. I'm exempt from taking the notary exam to become a notary. You get? I don't have to do it. I don't have to follow that procedure. So that's what exempt means.
But only in New York, as I understand.
Only in New York. But exempt means that there are certain procedures you don't have to follow. There are certain rules you don't have to follow.
Okay, so as you can see that there are 15 people who voted out of 15. Let's close the poll. Let's try. Okay, it's preparing the results. So, okay.
Wow, nice.
That's very interesting.
Yeah. Okay. Are companies with no specific business plan exempt under? No, they are not. You're right. They're not exempt. You know what I mean? They have to have a specific business plan in order to be able to claim exemption under Rule 504. Excellent. Very, very good. I'm pleased. Okay. Okay. Another poll. Sophisticated under 506 means what?
And those of our participants who are just joining, so as you can see, to join the voting, you type in your phone or a computer, vvox.app or www.vvox.com. So, but usually VVox app is excellent. Then type in the number, press join the session. You'll be able to answer the questions. Okay, so I think we need some time to answer. Because sophisticated under rule. Oh, this is such a difficult question. Because this is such sophisticated meaning in the first meaning for us. Such a sophisticated topic. Okay. We'll just wait for a little bit so we can see that 18. And after you have joined, you may just stay on this page, and when there are some new questions, you will be able to vote. I suggest we shut down the poll, Alexandra.
Okay. Yeah. The ability to evaluate potential rights and rewards and investments. So you have to be sophisticated. Sophisticated is used a lot in business. And basically when they say sophisticated, it doesn't mean that you dress well, you drink, sophisticated basically means that in terms of business and law, you know what you're doing, you know what's going on. Okay, very good. I could die now. VVox worked. Okay, so this is the end of basically Rule 506. And and the rules associated with exemptions under filing SEC. So Reg D, basically. So 506, Reg D, Rule 506. So this is basically the end. What you need to know basically is, one, okay, only certain companies can do it, usually smaller companies. There are certain securities. Once you issue those securities, you have to fill out Form D and issue it to the Securities and Exchange Commission. Bad actors cannot take part or cannot be exempt under Reg D. Okay, and we all know bad actors are people who are a lot of companies. Bad actors, disqualified people, but bad actors, when I say bad actors, are people who have sold securities fraudulently, people who have lied to the SEC. They're another group that is not exempt from Reg Z. So they can't claim exemption under Reg D, excuse me. All right, now basically we know that, and we just know that if you're dealing with 505, I believe, you can raise 10 million within 12 months. If you're dealing with 506, it's an unlimited amount, okay? But there are some results, but there are some issues that can stop you. So you have to check with your state law to make sure that you know all the laws that are relevant to the securities that you're trying to issue, and the reason why you're trying to and the reason why you can claim exemption under Reg D. Mm-hmm. That's basically what you need to know about Reg D. We could talk about securities all day, and securities are really, really boring, and I'm not a securities lawyer, so we're not going to do that. So we're going to start right now with agency. Any questions about this so far? If you think about it.
Yeah. So anyone, if there are any questions about the securities and Reg D, please write your questions in the comments. Although I bet everyone got so much horrified, Alexandra, by this. So although we might expect.
No, securities is extremely, you even see me kind of like losing it simply because securities is very, very complicated. And not only is it complicated, like it's like a 3-tier system, like a 2-tier system. You have the feds regulating it, you have the states regulating, every state is different, so it can be very, very, very complicated. So I'm not a securities lawyer. I'm like, okay, so I did my best, but that's the basics of Reg D. And it's important to know Reg D because you may be dealing with a startup, you may be dealing with a smaller company that may want to raise money, and that may be an option for them to do it. It may not be. So you have to do your legal research. All right, great. So let's start under agency. Let's start with agency. Okay, agency law is common law. So it's not in any statutes, and it's a doctrine which controls the relationship between principals and agent. A principal appoints an agent to act or work on his or her behalf, and an agent is a person who agrees and is authorized to act on behalf of another. Authorization is very, very, very important when you're dealing with agency law, okay? There are 3 forms of agency law: express, implied, and apparent. Agent authority formation, express authority. Expressed usually by a written agreement. Agent then takes the steps necessary to accomplish what is requested by the agent. I'm sorry.
It's okay. By the principal. Yeah, that's okay.
Mm-hmm. So the principal. So what happens is, okay, I have the express authority. When I say express, I have a contract with you. This is very, very common in real estate. Okay.
Oops.
So you
Alexandra. Hence. So
okay,
yeah.
You hire somebody to sell your house. Okay. Mm-hmm. It's expressed as a contract. That's basically it. Okay. Implied authority. Look at the principal's conduct. If the principal's conduct indicates that the agent should take action, then authority is implied. However, an agent does not have the authority to do anything expressly prohibited by the principal. So implied authority is, if you hire me to sell your house, then I have to show it. So I have the implied authority. Okay. It may not be expressed in the agreement, but I have the implied authority that I can show the house to whoever I want, unless that's expressed in the agreement that only certain people could see it. So that's implied authority. You look at the principal's conduct, and if the principal's conduct indicates that the agent should take action, then authority is implied. Okay. So if I'm showing the house to anybody and everybody, and the principal isn't reacting or isn't saying anything, that basically means I have implied, or the agent has implied authority to do so. Examples of implied authority. John wants to sell his car. He gives Linda all the information concerning the car, the year and model of the car, quirks of the car, color, and value. He then says to her, if you can get at least $10,000 for it, take it. However, you can't sell anything that is in the glove compartment of the car. Okay. Linda finds a buyer for the car. However, there was a book in the glove compartment, and Linda included that in the sale. John sues Linda for the value of the book. Will he win?
Okay, so everyone, we have a hypothetical situation, an abstract. So, and you may write your comments on YouTube. So it will take us some time to digest and to think about the answers. And glove compartment, yeah, so it's like, well, it's understandable. So we have already some answers. Olga says yes. Pavel and Darya say yes, he will win. So, and Marusia says, I hope not.
You hope not. Okay. First of all, okay. No, will he win? Most likely he will. Okay, because remember, authority is very, very important. So if she didn't have the authority to sell it, so she's in breach of the contract, although the contract is implied. And I gave this as an example of implied authority because he says to her, if you can get at least $10,000 for it, take it. So he doesn't give her anything express. There's no contract. There isn't anything. So anything that she has to do to sell the car to get $10,000, then she could basically do, because it wasn't expressed. It was implied. I give you the authority to sell the car if you can get $10,000. So that's an example of implied authority. Okay. And in terms of will Linda have to pay him back for the book? Yes, because he expressly told her not to do it. So she did not have the authority to do it. Although she had authority to sell the car and take $10,000 and do whatever she needed to do to get the $10,000, she didn't have the authority to sell the book. Apparent authority is when a third party reasonably infers that someone is authorized to act on behalf of another party, despite the fact that no existing express or implied authority exists. A principal can be bound for the acts of the agent, although no authority exists. For example, a nurse has apparent authority to accomplish anything a reasonable person would believe that job entails. Okay, I'm going to give you a hypo next. Apparent authority. Student nurse Laura is not trained to give vaccinations. She is training at a hospital, is dressed in a nurse's uniform, and nowhere on her person does it indicate that she is a student. During her rounds, she encounters a patient that needs a vaccination. She says to herself, this looks pretty straightforward, and I studied this last week. She gives the patient the vaccination, and things go horribly wrong. The patient sues. The hospital's defense is that Laura did not have authority to give vaccinations. The patient will win because.
Okay, so it will require some time for our viewers. And while we're waiting, I have a question regarding one word that was on the previous slide, but we will not go there yet, so to give time for everyone to write. So you said that there was infer. This word, this word is not very often used. So what does it mean?
You deduce that it's true. Okay, I'm a contracts attorney, so you infer that I know how to draft contracts.
So it's like you assume from the conduct. So you logically understand.
You don't assume. You base your thought. You base your reasoning on facts. Okay, so that's an infer. Okay. Alexandra is a lawyer. That means she went to law school. That's an inference. You know what I mean? It's based on the facts. So you look at the facts. You're not assuming. So that's what an inference is.
Yes. Okay. Thank you very much, because it's not that often. It's like very, very formal word. We don't see much in legal documents, at least in Russia, although it is it isn't counted in formal documents. And we have a question. Thank you very much. We have an answer. Thank you very much, Olga. She writes that Laura is a student, not trained to give vaccination, so she doesn't have the authority. And Yelena says, Pavel says, she didn't have a right to do vaccination because she wasn't a full-time an active doctor. So, and Daria says, Laura seemed to have apparent authority. The patient, that's an interesting view, the patient had no reason to doubt her authority, but in fact she didn't have it. So the patient was sort of deceived. And,
well, it wasn't deceived. She had apparent authority because there was nothing that says student nurse. She had a nurse's uniform. She was walking, doing rounds. So she had apparent authority to do it. So there was nothing that indicated that she didn't have the authority. So she had it. So the patient will win because she had the apparent authority.
So she's looked like, she seemed like.
Exactly. That's what apparent authority is. You know, she seemed that there was nothing, you know, when you have apparent authority, say for instance, this is very, very common. Say somebody signs a power of attorney. Okay. I give you power of attorney to manage my finances. Okay. Now, if I come every day and take money, okay, because I have the power of attorney, I'm taking money. I have a power. Okay. And I'm taking money from your account and I'm putting it in my account. Okay. There's no reason for the bank to stop me. Why? Not only do I have the express authority, but the power of attorney, but I also have the apparent authority. You know, I'm supposed to be taking money out. Okay, so when you have apparent authority, it's like, okay, it's a lot of times it's not implied, a lot of times it's not expressed, but I have the uniform, I have the credentials, you know what I mean? If I show you I work for the government, if I show you, somebody knocks on the door and shows you a government card and says, okay, I work for the IRS, I'm here to look at your taxes, and the person comes in and something happens, the person had the apparent authority to do that because they had the card. Okay, so you have to look at the circumstances. That's where apparent authority is formed. Here, the patient will win because what? It's apparent that she's a nurse. There's nothing that indicated, there's nothing that told me that she wasn't a nurse.
And
everybody
we have, yes, thank you very much. That was super understandable. And there is one more question about this apparent authority case or hypo. We have a small conversation in our comments. Daria asks, and who can be the defendant in this case? The nurse or the hospital?
The hospital.
And the hospital. And this is also, Yelena backed you up, the hospital. Yeah.
Okay, and basically, why do you, okay, they may bring the nurse in. Okay, I mean, first of all, she's a student, but what happens when you sue somebody? At least in the United States, you go after the person, and we're going to talk about vicarious liability right now. But usually when you sue a person, you go for what? The person who has the most money. She's a student. They're not going to go after her. They could make a connection with her and the hospital. They're going to go after the hospital because the hospital has most of the money. Okay, which brings us to vicarious liability. Vicarious liability assigns liability to a person who did not cause the harm. Okay. So a principal is always liable for the torts an agent committed while the agent completes their responsibility. Let me give you an example. Lisa is a truck driver employed by Sweet Drink Cola Company. She delivers sweet drink products to various supermarkets in Los Angeles. She accidentally hits another car and the driver of that car is injured. Sweet Drink is vicariously liable for Lisa's accident because she is their agent. Okay? So therefore, the nurse was acting on the student nurse was acting on behalf of the hospital and also acting on behalf of her school. So even her school can be brought in her school or the hospital can be vicariously liable for the injury that she caused.
So it's like liability for the actions of the third party, namely here an agent.
Exactly. All right. So I'm vicariously liable if my agent does something that's illegal. Then I can sometimes be vicariously liable.
Excellent. Thank you very much.
Okay. Hypo. Henry employs Linda to manage his properties. Linda has the authority to make all major decisions concerning Henry's properties. Linda finishes some paperwork concerning Henry's properties and heads home. She has a car accident and fatally injures a young man. If the young man's family sues Linda, can Henry be held vicariously liable for the young man's death?
Okay, I have a question, but probably this question will be asked by our viewers. So let us wait. So Daria says no. Let's wait for more answers. So, and there is a question I wanted to ask exactly. Marusia asks, whose car was she driving? Her car or Henry's car?
She's driving her car.
Her car. Okay, Pavel says that yes, sure. So okay, Henry can be held vicariously liable.
Nope, Henry cannot be held vicariously liable because Linda finished her work. She was going home. She was no longer working. So she finished her work and she was going home. So she was no longer, when she was on her way, she finished what she was doing. She was no longer in the agent world anymore. Now, if she was going home and she was going to deliver something for Henry, that would be something completely different.
Okay.
But no, she's just going home. So she's on her own. So no, Henry is scot-free. You were going to ask me a question?
No.
Okay. If a tort happens outside of official duties, the liability of the principal depends on whether the agent's acts were a frolic or a detour. Okay? All right.
Okay.
So.
And we're not familiar. Yeah, sorry, Alexandra. We're totally not familiar with the words frolic or detour.
That's okay. I'm going to explain it. So again, here, okay, so remember, Linda finishes her work. Remember, she's not working. So she's going home, okay? This has to do with when you're working. A frolic and a detour has to do when you're working. Okay. So basically, you usually analyze frolics and detours through the lens of employment law, okay? So basically, you have to look at the scope of employment, the employee actions that are required to perform work, okay? A frolic is a major departure from the scope of the principal and agent agreement. Principal is no longer liable for the acts of the agent. For example, Lisa decides to skip work for 2 hours to go to the bar. She gets drunk and hits another car. That is a frolic because skipping work in order to go drink is totally outside the scope of her employment. Truck drivers are never required to drink while working. So basically, Lisa's a truck driver. She says, oh, you know what? I really need to relax. I'm going to go to the bar. I'm going to get drunk. Or she has a couple of drinks. She gets drunk. She gets in behind the truck. And what happens? She hits somebody. Her employer is not liable because it's a frolic. It's a major departure from the scope of her agreement with the principal or her employer. You guys understand? It's totally unreasonable. Okay. Then you have a detour. Okay. A detour is a minor departure from the scope of the principal and agent agreement. Principal in this case is still liable for the acts of the agent. Okay. So Lisa is required to deliver sweet drink products to a restaurant. At the restaurant, she decides to have lunch. After eating, she slips and she hits someone in the face and breaks their nose. Sweet drink is responsible for Lisa's actions because it was foreseeable that she may have something to eat while at the restaurant. You see the difference? So it's a minor departure from the scope. So it's foreseeable that, I'm at a restaurant, it's lunchtime, that I can eat, but it's not foreseeable that as a truck driver, I'm going to stop, get drunk, and then drive. You see the difference?
And still lunch is considered to be within the hours of our work.
Yeah, hours of work, definitely. So circumstances considered outside the scope of employment. Independent contractor is a person who does work for a particular employer, but is not an employee. Examples are temporary workers and seasonal workers, okay? Dawn owns a trucking company and contracts with Sweet Drinks to deliver drinks to out-of-town locations. Dave is not an employee of Sweet Drinks, but a contractor who was contracted to provide a service. Sweet Drinks is not liable for his actions.
So, Can
Go
I ask
ahead.
a question then? So vicarious liability is implied only to our employment relationship.
No.
No.
Vicarious liability is
Like for no matter what, because here
for no
they're
matter
not.
what, if there's a principal and agent relationship. But in terms of frolics and detours, when you're looking that's usually in the scope of employment. That usually has to do with employment. Usually.
Mhm. Okay. So,
Okay.
because
So
here
I mean,
it's
go ahead.
not, yes, Sweet Drink is not liable for his actions, and why not then?
Because
So,
Sweet Drinks is an independent contractor. In this particular case, Sweet Drinks doesn't work for him. Sweet Drinks is working with him. You see what I mean? So they're not your employees. This is very, very major, and this is something that's going on in New York right now that's very, very major, and a lot of places in the US. So you have a lot of people who hire through an agency, they hire people to work for them. Okay. The person comes in, they may have a badge or whatever, but they're not their employer. An agency is their employer. That's an independent contractor, which means I'm there, I'm independent, I'm doing work for you, but I don't work for you.
Okay.
Makes a big difference. So he owns a trucking company. He contracts with Sweet Drinks to deliver their drinks, but he doesn't work for Sweet Drinks.
Okay. So that's, yes, it's understandable. So
Okay.
just clarifying the difference. Thank you very much.
Okay. Circumstances continued, considered outside the scope of employment, continued illegal acts. Usually fall out of the scope of employment. However, if you have a security guard that works for a particular entity and that security guard assaults another person, then vicarious liability can apply. Okay. So say, for instance, illegal acts, when you say, again, Lisa went to to deliver the drinks, and she decides to hold up the restaurant and take all their money. Okay. Her employer is not liable for that because it's an illegal act. But in the case of a security guard, okay, the security guard, the position itself, a lot of times or many times or may require somebody to use force. When you're a security guard, sometimes you have to use force. If you assault another person, then vicarious liability may apply because it's part of your job description. You understand what I'm saying, guys?
Okay, we have some comments. I'm just there are some questions, and I'm just trying to clarify them because they're not clear what is being asked. So apologies. So there is a question I asked to clarify. So Yelena asks, so there is this confusion between the independent contractor and employee. So she asked that the fact that the previous, so when we spoke about contractor and agent relationship, just the previous slide. So the parties are, that's Dave. So Dave contracts with Sweet Drinks. So he is a contractor for Sweet Drinks. And Helena says, why there is no liability? So they sign any contract? They do sign a contract between Sweet Drinks and Dave. Yes.
Okay. Yeah, they do sign a contract between Sweet, but Dave is not an employee. Okay, it's like, okay, say for instance, you total your car. You have a problem with your car, and then you hire a mechanic to come and pick up the car and take it to his place. Okay, the mechanic isn't a family member. Okay, the mechanic is picking up your car to go do the work. So the mechanic isn't a family member. An independent contractor does not work. They provide a service, but they're not employees. They're not considered employees. And like I said, there's a lot of that going. There's a lot of lawsuits going on in the United States right now because the line of independent contractor and employee is sometimes blurred. It could be blurred. You know, you could be like, okay, well, I wear your uniform. I have your ID. I come into your offices every day, but you're saying that I'm not an employee. I'm an independent contractor. So the line can be blurred. I agree with you. But if it's established that you are an independent contractor, then the person who hired you is not liable for your actions.
that is what is the most not understandable for our viewers, because, for example, a taxi, Uber, yes. So basically, at least in Russia, probably, I don't know. So imagine that there is an independent contractor, a taxi driver, and he or she, something happens during the ride. So it means that Uber is not liable. So, and there is a question, does it mean that Dave will be personally liable for anything that happens?
Yeah, Dave and his trucking company will be liable. Yes. Yeah.
Okay. So, and that is the most unusual for us, because so if even if they have a contract like of service agreement, so they are connected with each other. So it's within the scope of performing some duties for these companies. So they are somehow related to it. Yeah.
They are connected, but they're not connected under the purview of employer and employee. You see what I'm saying?
Yeah. But a subcontractor or a contractor agreement or service agreement, so there is still agreement. So, and that is the most difficult for us. So yeah, and we have comments by our viewers that Russian legislation are different from this, because it is different. Okay, thank you very much. That's why we can see the difference between our legal systems, and that is a discovery for us today.
Okay, so and again, like I said, under illegal acts, if somebody is, again, a scope of employment, if they're committing illegal acts, the employer will not be liable. But like I gave you a nuance, a security guard. A security guard is a job that requires force, so they may be, the employer may be liable because what? Force. Security guard is the scope of his employment, within the scope of his employment to act in a forceful way if he has to restrain somebody. Okay, let me read this. Hypo. Ian is a handyman and has his own company named iHandyman. Henry owns big properties and contracts with iHandyman to fix some of his tenants' refrigerators. Henry decides that the tenants would be more comfortable seeing his company's logo when sending Ian. So he gives Ian a shirt with a big properties logo and tells him to wear it, so the tenants will feel more at ease when letting Ian in. While fixing one of the refrigerators, Ian accidentally hits Miss Smith and breaks her nose. She sues Ian in big properties. Is Big Properties vicariously liable for iHandyman's actions? Is it reasonable to argue that Ian had apparent authority? Why?
Oh, that's a lot of. So we need to wait a little bit. So yeah, because it takes some time, and because we have a small delay when on YouTube we are broadcasting. And handyman, it means like a person who fixes everything. Yes.
Yeah, that's a handyman. Yeah.
So, and we start already getting some answers. So in answering to question, she sues on is Big Properties vicariously liable for iHandyman actions? Elena says no. We'll wait for the others. Okay, and we'll see how it goes. If there are some more answers, we hope. We're very grateful to our viewers when they contribute. And Pavel says, I think not. Big Properties is not vicariously liable. Marusia says also not. So we have some.
Okay, now let's move on. Is it reasonable to argue that Ian had apparent authority, and why?
Oh, that's another question. So, and also Daria said no. So now we're answering the second question. Is it reasonable to argue? I hope they were not answering the second question. So, okay, now everyone. So the answer to, now we have a second round of answers. So the answer to the second question is not. Some people say no, or maybe they're answering. So some people say no. Some people say, some of our viewers say, yes, it's reasonable to argue Ian had apparent authority, and based on this, Big Properties can be held liable. That's Daria. Pavel says yes, because he has a contract. Irina says that it is probably an apparent authority case because he wore a t-shirt. Olga says yes, Ian had the apparent authority, and Tamara says no. So we have, as usual, disagreement, which is very often.
No, it's arguable that he had apparent authority. Why? Because he had the shirt on.
Mhm.
Okay. He had a big property shirt on. Okay. If you have a uniform, if you're wearing somebody's uniform, that means you know what I mean? You had apparent,
Mhm.
So yeah. Yeah.
Okay. Thank you very much. Thank you, everyone.
Okay, terminating an agency relationship, lapse of time. Okay, so if parties said to a time period for which the agency relationship is valid, then after this time has lapsed, the relationship is no longer valid. For example, Valerie contracts with Sally to sell her house. The contract is valid for 90 days. Sally doesn't sell the house in 90 days. She is no longer considered Valerie's agent. Okay, so lapse of time.
Expiration, yeah.
Yeah. Purpose achieved. Some agents are hired to achieve a specific purpose. Once that purpose is achieved, the agency relationship is automatically terminated. Example, Valerie contracts Sally to sell her house. Sally sells the house. Once the sale of the house is complete, the agency relationship is automatically terminated. That's it. Purpose achieved. Mutual agreement. Both parties decide to end the relationship. The reason behind the termination is irrelevant because both decide that the relationship is over. This should be expressed in an agreement. Okay, so basically, if you're gonna, even if it's an implied agency, you agree on paper that it's terminated because one could argue, well, I didn't know it was terminated. So basically, mutual agreement. Certain events. Agency relationship terminates when certain events occur. Events include death, bankruptcy, pandemic, natural disasters, destruction of property, dissolution of corporation or partnership. So if, for instance, I have an agent to sell my house and my house burns down, there's no house to sell. So there's no agency relationship. Okay. Any questions on agency?
Yes, we do actually. The question, we have got two questions. One is from Yelena, speaking about some of the events, or not the ways how an agency agreement finishes. Should it be expressed in the agreement, or must it be expressed in the agreement?
No, like I said, all right. If you have an expressed agreement, okay, and for an agent, you could put a clause in there and says, by this agency will terminate by mutual agreement. The parties agree to give each other 10 business working days in order to end the relationship, et cetera, et cetera, et cetera. Okay, so you can put that in the agreement. But remember what I told you: some agreements aren't expressed. They're not in writing. They're implied. Okay, like this car. Okay, here's the car, here's the model, here's the make. If you can get $10,000 for it, you know what I mean, sell it. Okay, that's not in writing. But if I come to you and say to you, okay, well, you know what? Remember I told you if you got $10,000 for the car, well, I changed my mind. I don't want to sell the car. Okay, that would be nice if you put it in writing, simply because I can sell the car and say, well, you never said that to me. You told me to sell the car for $10,000, and I sold it. I found a buyer for $10,000.
And actually, we have two more questions. Speaking about the agency relationship, if they are implied. So if they're implied, if there are some disputes, are they actually enforceable? Do they often happen? You had some just oral agreement of agent-principal relationship, and something went wrong. So how are they enforceable? Can you actually go to court?
They're enforceable. They're enforceable, but you have to look at behavior. It's harder to enforce them, but you have to look at, behavior. If I tell you to go sell my car, I'm going to probably give you the car keys. You know what I mean? So you have to look at the behavior of the parties. And you base the implication on the behavior of the parties. Okay?
Yes,
that's very, very important.
Yes, and the last question we have, is about in general. So we study, that's a question from me personally, honestly. So we just to explain to our viewers that we do study agency relationship because we speak about business operations, and a lot, as I understand, not a lot, if we speak about business operations, the the amount of any operations made through agents, what would be the ratio, what would be the percentage? Is that a lot of companies work through agents relationships? So like why it is important for us to study, to understand.
Yeah, because, you know, if you're a partner in a company, you're an agent of that partnership. Okay. So anytime you act on behalf of somebody is very, very important. Okay, employer, employee. Remember, if there's an employee and employer relationship, that's an agency relationship
as well.
Okay, yeah, corporate governance. You know, we're going to talk about the board. A lot of times, board members can be agents of the board, and they could bind the board. So you find agency agreements all over the place. You know, on daily life, like I tell you, a lot of people when they get older, they give their children or they give the family members power of attorney. That's an agency agreement. I give you, you know, power of attorney to manage my finances or to manage my health care or whatever. So it's found, agency is found in almost every aspect of life.
Okay, thank you very much, because we very often, why I was asking, because we very often understand, not all, but some understand agent principal agreements in a very narrow scope. So, and here we understand that it's like very broad. So, and the word agent in the United States is very broad.
It can be very, very broad. Exactly. It can be very, very broad. And it's something that's common every day. And like I said, we talked about partnerships last time, and partnerships, like I said, very, very common. You know, you are a partner of, you can bind, you're an agent of that part. You know, once you're a partner, you're an agent of that partnership. So everything that you do, you know what I mean? Whether it's expressed or implied, you know, you can bind the partnership. So you have to really, really be careful of the relationships.
And in this situation, go ahead. So, and as I understand here, it is basically, we can say agent is a synonym of representative. So like,
I act on your behalf. I'm your agent. I act on your behalf. Even in a common day, you know what I mean? If I go, my mother gives me power of attorney for her finances. I am acting on her behalf, signing her name or signing my name on her behalf to take out money. You know what I mean? So you're acting on someone's behalf. You're representing someone.
Okay, excellent. Thank you so much. Now it's clear.
Okay. All right. Corporate governance. All right. Corporate governance are rules, process, and practices by which a corporation is directed and controlled. The goal of corporate governance is to balance the interests of the company's stakeholders, which include shareholders, management, customers, suppliers, lenders, and government. Okay. A stakeholder, I just explained this before, is a person who has a vested interest in the company, vested and established right or privilege. So when you have when you're vested, you have a right or privilege. Okay. Very important. The 4 P's of corporate governance are people, process, purpose, and performance. People, who is doing it and why? Process, how is it being done? Purpose, why is it being done? Performance, what are the results? So you're looking at the people who are doing it, okay? Who's your board members? Who are they? Do they have the qualifications? The process, are they following the rules? Are they following the rules of the bylaws? Are they following the laws of the state? Okay? Purpose, why are certain things being done? Is it to benefit the corporation? Is it to benefit the board? Why are certain things being done? Performance, what are the results? Okay, we're doing certain things, but what are the results? Are we making money? Because corporations make money. So, you know, how is this performance? You know, how are the results affecting us? You perform, we get results. How is it affecting us? The basic principles of corporate governance are accountability, very important. Board must be able to explain what the company is doing and the results of its conduct, must communicate important information to shareholders. Very, very important. You have to keep on telling everybody, remember, this is a board, and sometimes you may have, you know, hundreds or thousands of shareholders, you know, but you have to explain what the company is doing, be able to explain to the company, to the board member, to the shareholders, what the company is doing and the results of the conduct. That's very, very important. Transparency, timely, accurate, and clear information on financial performance, conflicts of interest, and risks to shareholders and other stakeholders. Okay, so you have a deal that's coming through, a merger. You have to tell them, okay, we have this merger coming where we anticipate that it may go through in about 6 months. But, you know, this is how this company that we're merging with, this is how they're performing. There are no conflicts of interest. Okay. And risks to the shareholders, there are no basic risks. Our shares or the value of the company is probably going to go up. If there is a risk, you have to tell them, okay, well, you know what? there's a possible risk, but we're merging with this company because we know down the line that they will be able to make money. So you have to be very, very transparent. When I say conflict of interest, what do I mean?
Which one?
Anybody? Conflict of interest.
Okay, so let us ask a question. So how would everyone understand a conflict of interest in general, or like in corporate governance?
Or in general, just in general.
Mm-hmm.
I mean, a conflict of interest is a conflict of interest.
Mm-hmm. Let's give some time. We can go with the slide and then we'll just wait for the answer, because it takes time to think and to type in, okay? And then we'll get back to these questions. So if someone is eager to answer, how would you define a conflict of interest in general? And we'll move on and then get back to you.
Okay, so we're continuing with the basic principles of corporate governance. Fairness. Shareholders, employees, vendors, community members must be treated with the same consideration. So, board has to be fair. Okay, responsibility. Responsible for the oversight of corporate matters. Its purpose is to support the growth of the company. All right, so you're responsible for managing the company and the growth of the company. You can't have a board of directors and the company is losing money. There's a problem there. Risk managers must determine the risks and how to control them. That's why you have to have a very, very sophisticated board, people with diverse experience, because they must be able to assess risk. I gave the example of the merger. You know what I mean? Okay, we're risking this. This company that we're merging with, they're not very, very profitable. Okay, is it too much of a risk to take? Are we willing to take it? If we take it, how is that going to affect us? So the board must be able to convey all that information to the shareholders and the stakeholders. Ways to assess corporate governance. Disclosure practices. How often and how well the corporation discloses what they're doing and the results of what they're doing. Okay, so if you have a corporation and they're not telling anybody what they're doing, how they're growing or whatever, there's a problem there. Okay. How they deal with conflict of interest. A conflict of interest, like I said, does anybody have a definition for conflict of interest?
Yes, actually we do. So we have got 4 options. So, and I'm very glad, thank you very much everyone who contributed. Marusia says, so a board member owns the company the corporation is about to merge with. That's as an example. So then Daria says, when your interests as part of company contradicts your other interests. Pavel says, yeah, so let me just read all of them because they're very interesting and we're so just happy that we have the answers. So Pavel says, for example, my relative is my supervisor. We're working in one department. So Irina says, when the actions made for the benefit of one person lead to some harm of another one. Ksenia says, oh, there is a lot. So I will very quickly finish up with them because when one party derives, oh, that's very sophisticated, derives a benefit or is able to do so, as well as bear some burden because of the position it takes up, for example, affiliation of friendship. For conflict of interest is, yes, one gets personal benefit for acting. So, and all of the above, a lot of options, a lot of different examples. Thank you, everyone.
Thank you, everyone. So basically, conflict of interest is when there's a contradiction, or there's a major contradiction, or there's someone is benefiting out of the actions. There's a benefit there. So as someone mentioned, the working with their nephew or family member. Mm-hmm. Okay, so you work with your family member, and instead of having an hour lunch, you get hour and a half. Okay, there's a contradiction there. There's a benefit to be. So that's where the conflict of interest is. So, okay, ways to assess corporate governance, disclosure, how you deal with conflict of interest, how frequently they are audited, and the issues raised in the audits, have they been taken care of? So if you're being audited and you're having problems with income, or you're having problems, your balance sheets aren't correlating, etc., has that been taken care of? That's very, very important. Social obligations, how they handle issues like climate change. Okay, so as a corporation, remember, you're a person. How do you handle issues that affect the community? You're part of a community. Okay, if you're polluting water, then you're not meeting your social obligations. Compensation of their board and executives. My question to you, and maybe 1 or 2 answers, Sophia, why would this be an issue? Compensation of the board and the and executives. Why would this be an issue when assessing corporate governance?
And as I understand, it seems like we are preparing for our next class when we speak about mergers and acquisitions. These are basically the checklist for or due diligence, if I may say so. So we'll just need, we'll just need some time to give our. I will not read all of the answers, but just some.
Yeah, give me a couple.
Provide.
Yeah.
Yes. So. Okay, so there is already an answer. Thank you very much, Marusia. The issue can be here because the compensation might be too high. And Ksenia says if top managers leave the company, they might be entitled to some golden parachutes, which are quite big.
Yeah, so it's basically, it's compensation is important because, people have to make money. Okay, so Hypo, ABC Company, a large national corporation, is interested in having you and some of your partners invest in the company. You have your counsel do basic research of the company, and they find that the company has not been audited in 2 years. Compensation for executives is 50% more than profits, and that they are constantly being fined by the government for dumping illegal toxins in water. You and your partners decide not to invest in ABC because why? You know some of the executives and they don't deserve the pay that they're receiving. ABC doesn't know how to assess risk. Their overall corporate governance is bad. Which one?
Okay, and you can just write the answer. 1, 2, 3. Can they have more than one answer?
No, it's only one answer.
Okay.
I'm going to choose an answer.
Right, so mostly everyone, we already started to having answers. Olga, Pavel, Marusia, they say it's 3. Olga
3.
also.
Yeah, the overall corporate governance is bad. You know what I mean? There's nothing, they're overpaying people, they're not being audited, they're not, they're dumping. So no, we're not going to do that. Okay, so boards. Okay, we're going to start with the boards. Some companies have either a board of directors or an advisory board, or they may have both. Board of directors are responsible for setting agendas, running successful board meetings, establishing committees, and other duties. They normally represent the company at public events. Board of advisors provides non-binding advice on how to run the company. The main difference between an advisory board and a board of directors lies in their respective legal status within the companies. Advisory boards do not have any legal powers compared to boards of directors who have full authority over corporate matters, such as appointing executives and shareholder voting rights on major decisions. So advisory boards are there to advise, and that's basically why. And usually you find advisory boards more so on nonprofit organizations as opposed to for-profit organizations. Okay, poll. How many board members are currently employed in the U.S.? Remember, this is a job, so how many do you think are currently employed in the U.S.?
Okay, everyone, so you need to get back those of you who jumped out of our VBox if you would like to. You can either go there, and it is fun because we can see very visual result, and you can just type in VBox app, write in the number of the session, and then vote. Or you can just vote, also write your answer on YouTube. So, but this one is very visual. Oh, that is such an interesting question. So, okay, also voting. And while we're waiting, so like 30 more seconds, Pavel says it's 32,000. Natalia says it's 19,360. So, and let us see.
We'll give it a couple of more seconds and we'll close the poll.
The other, Daria also says 19,360.
All right, I'm going to close the poll, guys, because we have a lot of work to. Yep, and that's it, 19,360. Yep, you're right. So, and remember, being a board, you're employed by the company. You get paid, although you meet maybe 3 or 4 times a year, you get paid for that. Okay. Okay, characteristics of an advisory board. Advisory boards is a group of individuals who provide advice or counsel to an organization that is not involved in its day-to-day operations. Advisory boards are created for special circumstances. An advisory board is useful when day-to-day operations of a company is needed, when a company needs to deal with various social issues, when counsel or advice is needed for a particular event or special circumstance. And when the last one basically ties in with the first one, because advisory boards don't deal with the day-to-day operations of a company. But if there's a special event or something is coming up, then they may deal with the day-to-day operations to fulfill that mission. Everybody understands that? Okay. If there are any questions, let me know.
Okay, yes.
Characteristics of a board of directors. Board of directors is central to a corporate governance because they are individuals trying to operate as a group. Remember, they're the brain of the corporation, this fictional person. They're typically chosen for their experience managing or directing other large companies. Okay. So remember, I said your board has to be diverse. They have to be experienced. They have to know law. They have to be able to assess risk. So there's a group of people trying to do all of the different minds, one body. Okay. Independents are considered helpful for governance because they dilute the concentration of power and help align shareholder interests with those of insiders. Independents don't share the ties that the insiders have, insiders of the company have. So if you're an independent and because when you have a board of directors, people usually hire board of directors, people that they know, okay, or people who are referred to them. So everybody knows what happens. You start picking people that you know. You get a group of people that know one another. They think alike, et cetera, et cetera, et cetera. Independents or outsiders are good because they don't share the ties with the with the insiders, and therefore the independents, their opinion is less biased. I would say less biased than that of the insiders. Board of directors, they hire the company's CEO or chief managing officer, and this person manages day-to-day activity of the company. The board of directors manage the overall direction and strategy of the business. Okay, which way are we going to go? Are we going to merge? Are we going to sell? Are we going to, acquire? Totally different things. Merging and acquiring are two different things. The board has a strategic function in providing the vision, mission, and goals of the organization. These are often determined in combination with the CEO or general manager of the business, okay? So basically what happens is a lot of times the board would meet with the CEO or the CFO or the managing people and say, okay, this is what we want. This is our vision. How can you make that happen? Or it could be the opposite. Remember, CEOs get a lot of money. The CEO says, maybe this is the direction we should go. How are we going to make that happen? Mm-hmm. So they're supposed to work together, okay? The boards establish a policy-based governance system or structure. In other words, the board develops policies to guide its own actions and the actions of the manager. The policies should be broad and not rigidly defined as to allow the board and manager leeway in achieving the goals of the business, okay? So policies, we need them, but they shouldn't be very, very rigid. And usually, in my opinion, when policies become rigid, that's when there's a conflict of interest. If you see very rigid policies, behind those rigid policies, there's always somebody trying to take advantage of something. There's always a conflict of interest. They govern the organization and the relationship with the CEO, manages his relationship with the CEO based on the governance structure. So they have a governance structure, and this is how they deal with the CEO. They also have a fiduciary duty to protect the organization's assets and members' investments.
We have a couple of questions. Let's open up the poll, and while there is a poll, I will ask these questions. Okay, so
what is the average salary for a Fortune 500 board member? Fortune 500 company is a company like Walmart that makes a lot of money, has a lot of different branches. So what do you think is the average salary? All right, ask me the question.
So, and also you can vote on YouTube. So there are two questions. One is very specific. So the first question from Daria: am I right in thinking that these people, board members, are shareholders of the company, or they're only employees from the outside?
Okay, so some board members could be shareholders, some could be, but usually what they're people who are chosen, who are employed by the company. They meet maybe 3 or 4 times a year. Okay, depending on their articles of incorporation, they meet 3 or 4 times a year to basically strategize how the company is going to be run or the future of the company. Okay, so that's basically what they are. So they're not employees. They're not like if I'm a lawyer for Coca-Cola. No, they're not employees. They're a board. They get paid, and I say they're employees because they get paid. Okay, but they come in 3 or 4 times a year. You know what I mean? They strategize. They, update governance structures. They deal with the CEO. They see what's going on, et cetera, et cetera, et cetera. But they are not employees.
Okay. So thank you very much. And there is a second question, which, and Daria is very grateful for the explanation from Ivan, but it's very, very specific. I'm not sure, probably can we answer it or not. Why would a team like Zipia estimate board members' demographics and statistics?
Okay, so why would they estimate?
Their board members or board member demographics and statistics. So.
Okay, and the question is in reference to the board members' demographics and statistics. The question is what?
Yes, why would a team like Zipia would estimate the demographics of board members? Maybe we should ask Ivan to clarify this question, because I also don't get it much. Sorry, Ivan, we don't get it. So can you please rewrite it? If we have time, we'll answer. And we have some answers in YouTube. So, and it's 150,000. So from several people.
No. I'm surprised you guys got this right, because I got it wrong. 321,000 for Fortune 500 board members. They get a lot of money. So imagine working meeting 5 times a year and making $321,000. It's not bad. Okay, very good.
And they can do some other stuff in between, as I understand. Yeah.
So. Yeah, they have their own jobs. I mean, being on a board is like a very prestigious thing, because you're getting paid to give your advice, and you have your regular job. Yeah. Okay. So the governance models, as I talked before, how the boards govern, manager focus. When you have a charismatic CEO who is dominant in the organization, the manager or CEO dominates the board. In this case, the board becomes an advisory board and reacts to the views of the CEO or manager. So you have this wonderful guy who's very, very charismatic. He knows a lot of people. So basically his agenda, he's charismatic enough to go to the board and say, this is my agenda, and I would like you to implement it. How are we going to do it? So he's basically controlling the board. That's the manager focus. Okay. Then you have a proactive board. Speaks as one board, in addition to having a proactive CEO that speaks the one combined voice of the organization. So the CEO and the board, they work together. So you have the voice of the board, the voice of the CEO, that they combine. And once they're combined, they're the voice of the organization. This is a good model, the best model, because both the CEO and the board are on the same page. Okay, so everyone knows, okay, this is what I like, this is what I want. Okay, how are we going to make it happen? And then you have the geographic representation. With this model, the board members feels that they have been elected to the board to represent individuals in a geographic location or a special interest group, usually found in large boards. Doesn't work well because many times what is right for the corporation can be ignored in favor of the interests of the geographic groups. Okay, so what happens is, say for instance, you have a large board where you have like maybe 100 board members or whatever, or 50 board members, and they pick people from a particular geographic, most of your shareholders are from New York. So you try to put most of your board members, choose most of your board members from New York, and you put them on the board, and they basically represent the shareholders from New York, because the shareholders of New York are the majority. Okay. It isn't a very good model, because what happens? Those people become biased. Okay. They become biased. They become, their mind runs one way. Okay. This is how we do it in New York. This is how we do it in New York. This is how we do it in New York. New Yorkers want this. New Yorkers want that. There are other board members. And just because it's done in New York doesn't mean it's the best way to do it. So that's the geographic representation. Again, there are other models. I only gave you guys 3 for the sake of time. Okay. So, in your opinion, which one is the best model? Okay. You know what? Hold on. I'm going to skip this question because we're kind of running out of time and I want to get through some stuff. Okay. Okay. Again, what percentage of board members in the US are female? What do you guys think? I'm not going to do the poll because we're
running out of time. Yeah.
Yeah. Okay. So the corporate veil protects the shareholders, board members from being liable for the company's actions. There's a clear distinction between the corporate person and the owners of the corporation. Okay. When the corporate veil is pierced, the corporation's shareholders or directors are held responsible for corporate debt or actions. Okay. Instances when the when court pierces the corporate veil, there is no real separation between the companies and its owners. For instance, commingling of assets, conflict of interest. There are a lot of conflicts of interest. Okay, so the board isn't really operating for the benefit of the company. They're operating for the benefit of the board or a particular board member. The company's actions were wrongful or fraudulent. The company's creditors suffered an unjust cost or loss. Okay, so that's when the court pierces the corporate veil and says, you know what? You guys are liable. The board is liable. Pay out. We're going to come after you. There's a saying, you can't use the corporate veil as a sword and a shield, which means you can't use it to do wrongful or fraudulent things and then claim it as your protection. For example, yes, we did wrong, but we're protected. Sorry, you can't do that. Okay, that's when they say you can't use the corporate veil for a sword and a shield. No, you can't use it to do wrong and then claim that you're protected from it. Okay, last of the fiduciary duties of the board members. Fiduciary duties are legal responsibility to act in the best interest of another party. The first fiduciary duty is the duty of care, legal obligation to protect the safety and well-being of others. Okay, so you have the legal obligation to protect the safety and well-being of others. Remember when I was talking about in terms of the community and illegal dumping or whatever, you have a duty of care to protect the corporation and to protect the people that are involved or the stakeholders of the corporation. You have a duty of loyalty, requires the directors to place the interests of the company and the shareholders before any of their personal interests. Okay, so I'm loyal. Okay, so I know that this stock is going to be good for me, but it may not be good for the company. So I'm going to go with the company. Duty of confidentiality, must not share confidential information pertaining to the business. Duty to disclose requires the directors to disclose to shareholders, etc., all the facts and circumstances relevant to the director's decision. So duty to disclose is a big one. You can't keep secrets. If you're doing something, you have to disclose it. You can't keep secrets. It's not good to keep secrets. Okay, so this will be the last hypo, I believe. John sits on the board of the perfume company. He voted along with the board that perfume companies should buy Smell Good company. John owns stock in Smell Good and knows the value of his stock will substantially increase if it is bought by perfume company. He did not tell the other board members that he owns stock in Smell Good. John breached his duty of what?
I think that's an excellent question. So, and we'll just wait a little bit over here. So, and we are starting getting some questions. So,
and it could be more than one. It could be more than one. It could be more than one.
So, and that is interesting that Ivan says disclosure, Olga disclosure, Daria says all of them. So,
yeah, disclosure and what? Loyalty.
Then conflict of interest, disclosure, 4 and 3, confidentiality and disclosure. So most of our viewers are going for disclosure, although Daria says all of them and Pavel says 4 and 3.
Yeah, the disclosure is the main one. Disclosure is definitely the main one. But also, basically, loyalty too. You know what I mean? Are you being loyal to the company?
Yes, and Daria and Irina, they back you up. Yes, so they say also loyalty and disclosure. Thank you.
But disclosure is the main, because he had to disclose that. He has to give that information. They have to know. They basically have to know. There was a question you were going to ask, Sophia. I don't know if you ever asked it.
I already forgot. So.
Oh, was somebody the question that I didn't understand? Remember
So, and actually we have a situation that our viewers already answered this question.
Okay, could you explain it to me and answer?
Yeah,
Tell me
so
what it is?
yeah. So Ivan clarified this. He says like, well, the data in the poll is taken from ZPS study. He says though there's someone familiar with some information. My question is, why do they study actual facts about number, race, and gender of our members of board? So why in general do it?
Okay, it's very important. Okay, it's very important. Remember, what do corporations do? Corporations basically kind of run the world. You know what I mean? From Uber to Pepsi Cola to McDonald's to Walmart's. Okay, it's important for the gender because you need to have that representation. It's not good to have just the male perspective. Remember, I was telling you, you try to make the board as diverse as possible because you need a lot of different viewpoints. You need lawyers, you need risk managers, you need business people, you need finance people, you need medical people, because they all bring a different perspective. So if you only have a board that has most of the board members are men, okay, you're going to have a male perspective, but you have companies that are affecting women. You have cosmetic companies. Well, you know, what do men know about cosmetics? You know what I mean? You have companies that are making undergarments for women. What do men know about that? Should they be sitting on the board? You know what I mean? Should a man be telling a woman how her undergarment should, should fit? Not necessarily. So it's important. Demographics are very, very important because you have to know who's deciding what. And you have to try to make the board as diverse as possible to get as much feedback as you can. And I was surprised it was 54% because there was a time maybe 5 or 10 years ago that there were less women board members. Now I see that it's increased, which I'm very pleased with.
Okay, thank you very much.
Okay, so that is it, I believe.
Yes.
There were some other questions that I didn't ask because we finished right on time actually.
Yes,
so
we are. Yes, and
okay.
thank you very much for that.
In next couple of weeks we're going to do mergers and acquisitions, I believe, guys. Mhm. Okay. Thank you, guys. See you next time.